If the district court says the agency guidance violates the APA, then they can vacate the guidance and the agency can't use it going forward. And so you can still resolve both claims, but they got to go to the right courts. They tried to distinguish California again in two other ways. It's about money damages. You want your money and the guidance says you're not getting it. That's the remedy. It's the only thing the court can really do. They can prohibit the guidance, but the law says you got to go file your money claim somewhere else. You know, this past spring, as March turned to April, as March turned to April, thank you for explaining the progression of the months. Victory for the Trump administration in a very close decision that has some interesting complexities to it, including the answer to the question, what is John Roberts doing? The Chief Justice of the United States of America. Got a 5-4 decision here with a nice decision from Justice Gorsuch as well, who is scolding the lower level courts for refusing to abide by the Supreme Court rulings. We're talking about judges like Boasberg and Zenas and others who think that they can continue to exercise jurisdiction over cases even though the Supreme Court has stripped them of it. Now we got a decision from the court, and we also got a dissent from Justice Jackson. She's being very Justice Jackson today. So this came down in the case of National Institutes of Health versus the American Public Health Association. All these associations suing, saying, you can't take our money away. You can't stop us from continuing our grift for all eternity. Now what we have here is the application for a stay of the lower level ruling that went up to Judge Jackson is granted in part and denied in part. Here's what we've got happening. The application is granted as to the district court's judgment vacating the government's termination of various research-related grants, saying the APA and their limited waiver of sovereign immunity does not provide that the district court with jurisdiction to adjudicate the claims based on any of this. And while the loss of the money is not typically considered irreparable harm, that is not irrevocably expended. Chief Justice Roberts is joining the left, Sotomayor, Kagan, and Jackson, who would all deny the application. Now others, Alito, Justice Gorsuch, Kavanaugh, and Thomas, okay, so we got a 4-4 kind of a split happening here. John Roberts joins the left. We've got another 4 over here who would grant the application in full. And Barrett is kind of splitting it. So it's a partial grant of the application for a stay. Here's what she says. In recent months, the National Institutes of Health has worked to align its funding with Trump's policy orders. They issued internal guidance describing the new priorities. They say, we're not going to fund DEI objectives. We're not funding gender identity. We're not funding COVID. It's our priorities. Nor will it continue the practice of awarding grants to researchers based on race, which is crazy. After review, NIH issued numerous decisions terminating existing grants, and various plaintiffs sued, challenging the documents. You can't take our money away. The district court said, yeah, you can't take their money. That's unlawful. And they vacated Trump's guidance. They said, nope, sorry, Trump, you're illegal. We're in charge. The First Circuit denied the government's request for a stay. Both courts treated this termination as distinct, like the agencies are separate and apart and they can run themselves outside of the executive branch. So the government sought a stay. Now, as today order states, the district court likely lacked jurisdiction to hear the challenges to the grant terminations, which belong to the Court of Federal Claims. You filed in the wrong jurisdiction, in the wrong court. You don't have the right to come into this court and make the claim that the government canceling your grant is a constitutional violation or some violation under the APA. But in my view, the government is not entitled to a stay of the judgments insofar as they vacate the guidance documents. Well, let's see what she says. Plaintiffs frequently seek vacature of internal agency guidance on an arbitrary and capricious grounds. Now, that the agency guidance discusses its policies does not transform that into being well-founded. Now, she says the Chief Justice and Justice Jackson, they say that because the district court is the right forum for the challenge to this guidance about how the decisions are being made, it is necessarily also the right forum to challenge the terminations. That's from Roberts. But both logic and law, however, support channeling challenges to the grant terminations and the guidance to different forums. Like if you're upset about Trump's order saying that you can't give, grants to black people or something just by virtue of the fact that they're black, which I thought was like discriminatory or something, but they have, they figured out. So they say, you get this because you're, black. So they sue, somebody sues. They say, well, the decision about revoking that, like the policy internal documents and guidance, that's one claim. But the person who got the terminated grant, let's say like a black person, for example, they lose their grant. They have a separate claim, right? Challenging the guidance separate and apart. I have been harmed. I lost my grant. I got it under Joe. It's not because I'm black. It's because of these other things and I'm doing great work. And now I'm going to make my claim that my grant was wrongfully terminated. That's great. That's separate from Trump's entire new policy. And this is what Amy Coney Barrett is saying in breaking this apart. Now, Roberts and everybody and the left would say that all of this can be just, bundled in together in one claim in DC. Amy saying you got to split them out. And she'll uphold the guidance challenge, but not the other challenge. So first, vacating the guidance does not reinstate terminated grants. If one simply flowed from the other, they would have just only needed to vacate the guidance itself. Here, the district court separately vacated the grant terminations and ordered the government to pay them money. Now, second, the law, right? So the facts just don't make any sense. She says there's kind of separate things. Even if the guidance and grant terminations are linked, if you vacate the guidance, it does not necessarily void the decisions made under it, as other case precedent says. The claims are legally distinct. And if the CFC has exclusive jurisdiction over terminations, the other jurisdiction, then they can't get around that exclusive jurisdiction by trying to say that we're going to package this as a constitutional claim. Right on. Two-track litigation results from the jurisdictional scheme governing actions of the United States court, which often requires two separate actions. This is a lot of work. You got to file in two places. And Justice Jackson is not right either, says Amy Coney Barrett, that they're not going to have any relief in any other forum. Each forum can fully adjudicate their claims. If the CFC says the government breached a grant agreement to that specific one, it can award relief to the grantee. If the district court says the agency guidance violates the APA, then they can vacate the guidance and the agency can't use it going forward. And so you can still resolve both claims, but they got to go to the right courts. Jackson's fundamental objection is sending the grant termination claims to the CFC. But California, that other Supreme Court case, has already addressed this. This is not even a big deal, all right? If you've got two separate claims, you file in two different locations and you resolve them. Now, it's true that they cannot necessarily sue the government in two forums simultaneously because there's some overlap here, but there's other guidance, and we don't even know that this is a final agency action yet. The government did not press this argument or any others, but its application largely ignores the guidance, and so the government has therefore failed to show that it's entitled to a stay of judgments insofar as they vacate the guidance, all right? Of course, it remains free to challenge the district court's vacature of the guidance before the First Circuit, and they can do that too, right? So Trump's guidance is basically stayed according to Amy Coney Barrett, but the terminations are valid because they sued in the wrong location, okay? So like $700 million or whatever the total number is can be properly disposed of because those can be terminated. They filed in the wrong place. So the stay is applied to those terminations is invalid, but the future cancellations are stayed and Trump can appeal all of that in the First Circuit. So thank you, Amy Coney Barrett, for that. Now, here is the decision from Robert trying to figure out why he went this way. He says, in my view, the district court's vacature of the challenged directives distinguishes this case from our prior precedent. This relief, which has prospective and generally applicable implications, falls within the scope of our jurisdiction at the low court. And if the district court had jurisdiction to vacate the directives, then it could also get the terminations, right? They're one and the same. The government has neither contended the terminations did not result from the directives, nor contested the conclusion that they were final agency action. And so, in these circumstances, it's one case, it's not two cases, and Robert says they were not required to split the case into two parts. Okay, so very short distinction here from Roberts, but Sotomayor, Kagan, and Jackson are joining him, saying, really, the government didn't do a good job at challenging this separation between the two, and the district court is not required to do it, and so they can resolve both things, and that's it from Roberts. So that's essentially what we see from Roberts plus the three libs. Then we get Judge Gorsuch. Now, Gorsuch is unhappy with the lower level courts, and he rips them here appropriately. Kavanaugh joins in on Gorsuch, and Gorsuch is the man. Lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them. And we know who he's talking about right here. Department of Ed versus California and these other cases like Judge Boasberg. Now, in the Department of Education case, this court granted a stay because it found the government was going to win in showing that the district court did not have jurisdiction to force the government to pay money. California, in that case, right, the Supreme Court case, explained that suits based on any express or implied contract with the United States are not APA claims. You can't just sue because you're mad. You have to go to the Court of Federal Claims. There's something called the Tucker Act, and you have to sue there. Rather than follow that direction, the district court in this case permitted a suit involving a materially identical grant to proceed to final judgment under the APA. Gorsuch is saying, we've already dealt with this. We've already had cases that are very similar. People are mad they lost their money. money. We said sue in the Court of Federal Claims. You're not doing it, says Gorsuch. And you might disagree, but you cannot defy us. Now, as support for its course, says Gorsuch, this lower level judge invoked what he says is persuasive authority. And persuasive authority, which he's calling the dissent in California, which are in the dissent. It is not persuasive. Decisions regarding interim relief are not necessarily conclusive, and it's still ongoing, but regardless of your procedural posture, no matter what you want to call this, an interim proceeding or whatever, our reasoning carries precedential weight in future cases. You can't just ignore it. And it's binding just as well as the rationale and the reasoning underlying it. In California, the Supreme Court case was clear. Our reasoning was very clear. There, we explained that the APA's limited waiver of immunity does not extend to contracts and money claims. Instead, you have to go to the CFC, Court of Federal Claims. You're mad that you lost your government money? Go sue over there. The Tucker Act was created. There's all these laws that say this is the appropriate forum to do it, so go do it. But they'll lose over there. They don't want to go over there, so they want to go to their rigged judges, and the judges can issue nationwide injunctions and ignore the Supreme Court. Where is Congress on this? This is a judicial insurrection. That reasoning binds lower courts as a matter of vertical stare decisis, which is literally what I just was describing here. It's vertically integrated. It's not persuasive. A dissent is in the losing decision. It's not persuasive because you like their decision better. It's malpractice to cite the dissent. It's wrong. He's calling it out. Moreover, even probabilistic holdings like California's top line conclusion that the government is likely to succeed must inform the government how to proceed. And so if nothing else, the promise of our legal system is that like cases are treated alike. Yeah, right. Tell that to President Trump or the January 6ers, okay, who got abused by the prosecution that is supposed to adhere to this, but they don't do that at all. Hillary Clinton got about $100,000 fine for her financial fraud, which was creating the Steele dossier, paying for that, calling it a legal expense. She got a fine from the FEC. They charged Trump with 34 felonies for paying his actual lawyer legal expenses, not creating a fake Steele dossier or anything like that. So they're not treated the same, okay? If you are on one side of the political aisle, until recently, you have been the subject of government-endorsed and sanctioned abuse officially, and you were scolded if you didn't comply about you're killing somebody, you're a bigot, or you hate some segment of society. So here, this is persuasive authority, right? This is like, how dare you? That a lower court ought not to invoke persuasive authority of a dissent or a repudiated Court of Appeals decision that reaches the different conclusion that you prefer. Now, to be sure, beyond expressing mere disagreement with California, the Supreme Court case, the district court also sought to distinguish it to justify his crap decision. But that effort failed too. This case, the district court said, is a little bit different because the only claim is about discretionary grants. He says, no, the same is true here. That's not distinguished. The only injury the district court sought to remedy is money. And so money is what California talked about. And perhaps sensing the problems with the district court's approach, the Court of Appeals tried to help out like a bunch of other hacks. They tried to distinguish California again in two other ways. It's about money damages. You want your money and the guidance says you're not getting it. That's the remedy. It's the only thing the court can really do. They can prohibit the guidance, but the law says you got to go file your money claims somewhere else. So they know that they're going to go lose their money claims because the government has discretion to cancel those. And so they just make it up as they go. Even the Court of Appeals. First, the Court of Appeals said the lower court actually didn't invoke the APA, talking about money damages, but only invoked the APA to vacate the decision about the grants. Now, this court's precedents, however, cannot be so easily circumvented, you cheaters. An order vacating the government's decision to terminate grants under the APA, in every meaningful sense, an order. It requires the government to pay. That's it. You can call it whatever you want, you can change the label, but the remedy, money. That's it. Even the district court knows this, instructing the government that its vacation of the grant terminations means pay them, give them their money. Second, the Court of Appeals said, well, unlike California, here it doesn't depend on the terms and conditions. But that is also incorrect, writes Gorsuch. In both cases, the injury and the alleged right to payment are coming from the refusal to pay. Same thing in all the cases. So our precedent holds. For these reasons, I concur in the court's decision to stay the district court's judgments, vacating the grant terminations. If the district court's failure to abide by California were a one-off, like if this was just one lunatic judge who was just acting a fool, perhaps it would not even be worth writing to address this if this was an aberration on one bad judge. But it's not. Gorsuch says, but 2 months ago, another district court tried to compel compliance with a different order order of this court that we had stayed. In the DVD case, this is Boasberg, right? Boasberg says, well, I'm going to hold you in contempt. Your injunction was illegal, so you don't get to enforce your illegal injunction with illegitimate contempt powers. Still, another district court recently diverged from one of this court's decisions, even though this case in hand did not differ in any pertinent respect from the other one we have decided. So Gorsuch says, this is now the third time in a matter of weeks this Supreme Court has had to intercede in a case squarely controlled by our precedents. All these interventions should have been unnecessary, but together they underscore a basic tenet of our judicial system. Whatever their own views, judges like Boasberg and Zenas and the rest of them are duty-bound to respect the hierarchy of the federal court system created by our Constitution and the Congress. 100% right. And they're just trying to pervert the Constitution and the Congress because they are upset about the outcomes that they're going to get. We don't like what you're going to do. So they have to go to Maryland. They got to go to D.C. Here he shreds Jackson. He says, Justin Jackson in her whiny dissent, she suggests that individuals enjoy a free-floating right under the APA. But she's wrong too. To sue under the APA, it's not a free-floating right, says Gorsuch. What are you talking about? Crazy? To sue, a litigant must suffer legal wrong because of agency action. It says that right there, 5 U.S. Code 702. It's not a free-floating right. Where'd you get that? And here, the alleged legal wrong is money, a point that the dissent elsewhere even acknowledges. Now, I would have stayed the remainder of the judgment, which vacated any internal agency guidance as well. The only injury that gave them standing to sue was the money. They should have sued in the right location, and they didn't. And so they should lose more thoroughly than even Amy Coney Barrett says. So Kavanaugh came out and he said, like Gorsuch, Alito, and Thomas, I would grant the stay in full, right? So similar to Gorsuch, your money claims should be brought over there and the guidance claims are about the money. Okay, so bring them over there. He says, first, the grant of terminations are in the Court of Federal Claims. Okay, easy, similar to Gorsuch. Second, I also agree with the government that the grant termination guidance is also unavailing. For instance, he says it's not evidence that their challenges are separable, but even if they were separable, they're still going to lose on that claim, right? So here Kavanaugh, which is a good point, he's saying, look, even if we validate that claim, you're still going to lose. Like the guidance is valid, right? So you have to show why the guidance is invalid. He says Jackson seems to suggest that we can avoid this forum channeling decision by just denying the application and like all this will be fixed. He says that's ridiculous. We can't deny it. We have to decide this. Denying the application would mean that the suit belongs for now in the First Circuit, and it would mean that another suit belongs in the Court of Federal Claims. And so we got to decide this. And so for these reasons, Kavanaugh says, I would sign on with dismissing in full. Let's hit a little bit of Jackson. She says, okay, concurring in part and dissenting in part, right? Because part of the stay has been granted in favor of Trump so that he can cancel the contracts, but the guidance is still stayed, right? The guidance from going into effect is still stayed. So Trump cannot continue forward with this. It can still happen, but it's just got to work its way through the Court of Appeals. In other words, SCOTUS is not settling that now. So Jackson, she writes, Ketanji on the left says, this past spring, as March turned to April, as March turned to April, thank you for explaining the progression of the months. The court took a mere 9 days to address a difficult and nuanced legal issue, saying whether Trump can fire people. I viewed the court's intervention in an emergency posture. Okay, so they always do this. Like if they don't like the outcome, they just say it goes too fast. As it turns out, the court's decision was an even bigger mistake than I realized. Wow, she's blogging again. The court's reasoning in California was also possibly wrong, and it evidently resolved more than a jurisdictional dispute. And this shows what's happening. And for a cautionary tale, let's look at the docket. And now the court is lobbing a grenade into this. And here she's, rant about the NIH. They're amazing. Historically, they get a bunch of grants. Trump canceled them. And now, oh no, HIV transmission, Alzheimer's, cardiovascular disease, everyone's going to die. So they sued. Now Trump is terminating these things at scale. And what the court is doing today is not legal or practical. And so unfortunately, she says, this newest entry in the court's quest is not the last word. For the sake of the public, one can only hope that the grant recipients get their money. Yeah, we know. They just want their friends to all have endless funding on behalf of the American taxpayer. Well, not how it's going to work anymore, okay? They can go get their DEI funding somewhere else and pay for their research or whatever it is they're doing with their little playwrights and whatever they're doing. So, my friends, good sort of victory from the Supreme Court. Big chunk of money's being canceled. The rest of it is probably going to cancel. Like, I'm sure that guidance will ultimately ultimately be found to be valid, but we're just not there yet. And so we'll keep our eye on it. 5-4 decision. Interesting perspective from Roberts joining with the libs. Why did he not think that it was a CEFC situation? He didn't give us many details, but big decision from SCOTUS. So thanks for subscribing and joining as we do.